started the Weber Conference in 2008. We've organized the conference annually, normally in Accra, but in 2012, we had the conference in Abuja. And so over time, as the Weber Conference developed, the other thing which also happened was, we brought in speakers from all over the world. Some of them come to give what we call a keynote address. And some of these keynote addresses, 45 minutes, things like that. With time, we thought to ourselves, actually, when all these intelligent, clever people come to Ghana and they come to give a keynote address, can't we also organize a workshop, which they can do for, like people in industry in Ghana, so that they come not only to give a keynote address, but they come and they also impart their knowledge to people in industry, to construction industry practitioners. And so in 2012 or 13, we began running workshops and seminars like this for practitioners. And it grew, it grew year on year, it just kept growing. And at some point last year, we thought we would do a construction law seminar. While I was doing my own PhD at the University of Reading, part of my PhD had been focused on construction law. And so when I finished the PhD, I was appointed as a lecturer at the University of Reading, and the subject I was teaching, together with Professor Will Hughes, was construction law. And so it was around this time that I began developing the expertise and the interest in the area of construction law. So I moved to South Africa, and when I moved to South Africa, I came across a young, fine man, very intelligent lawyer called Rob Mawson. And we teamed up, and for about 5 years now, we've been working together to deliver the construction law program at Wits University. And so it was at some point last year, when I came to Ghana, and I thought it was time to do something like that here. When you look all over us, all around us, a lot of building projects, have sprung up in Accra, and we're building all over the country. And every day, we engage in construction contracts. And one of the big gaps, I find in the country at the moment is a lack of, can I say maybe a lack of expertise around the area of construction law, and not just in Ghana, but it's all across Africa. As I speak this morning, there isn't a single university in Africa which offers a degree or program in the area of construction law.
And I'm incredibly humbled and honored that Sam asked me to do this. And I'm hoping that through the course of the next 2 days, we'll share some thoughts and hopefully walk out of here, all of us, a little bit with a bit more knowledge and a bit more informed about the industry that we love so much. The whole thing for me is always about understanding and rethinking. We tend to make things too complex sometimes. There's a big difference between law and engineering, and I like to call that the great divide, but it's very simple to bridge it. So let's look at a set of basic principles. What is a contract? A contract is an agreement between two or more parties with the intention to create legal rights and obligations. It's as simple as that. In some jurisdictions, to be a valid contract, you require what's called consideration. And that's not the same in all jurisdictions, i.e. some form of value, some form of consideration. So in the Roman Dutch jurisdictions, we would use one terminology. In the English law jurisdictions, we would perhaps use a different terminology. But in effect, they're very simple. All it is if the contract is subject to a suspensive condition, the contract is valid, but it only becomes operative and we have to comply with it if something happens. On a resolutive condition, it's the opposite. The contract is valid immediately, but it lapses if something happens. What happens if you breach a contract? Well, there are many types of breaches, and a breach is essentially a failure to perform.
Yes, I was the Chief Justice of the Gambia. You want to know how a Ghanaian becomes the Chief Justice of another country? I worked for the Commonwealth as a Commonwealth expert judge for a number of years. There are 3 issues I would like to discuss with you as a friend of the industry. The first issue is the importance of long-range planning for the products of the industry and the need to promote that culture in our society. The second issue is the need for strategic arrangements to ensure truly professional development and practices within the industry in order to protect the environment and ensure proper growth of the industry. And the third is an idea that I have decided to champion because I see it as having great potential, and that is the development of a new economy around alternative dispute resolution of international construction disputes within Ghana.
So the journey for me was to identify these areas and see how, as lawyers, we can use law to help the contractor, the architect, the QS, and all those others who are related to the activity when a problem arises, or to assist them to negotiate transactions that would work for both parties, and also to see how we can use the law to avoid disputes.
Access doesn't mean come in and start working, because I can come in and start working and I can have my team there. But if I can't actually execute my work, do I have access? Lots of that tomorrow.
Well, on that note, I'd like to thank you all very much. Thank you, Rob. Thank you, Mr. Lecha. I think it's been a great first day.